mainly by talking to you about an institution which you probably have never heard of. It was discharged by breach. If there is a contract and one of the parties tells the other it will not fulfill its obligation, then in English law, the creditor, the one who has been told, has two alternatives. He can wait until the time comes when the form is due and can ask them for damages, or he can immediately say, all right, I got fed up with it, I have to bring the contract to an end and get damages thereby. What you can't do is wait and perform your contract when you know that the other one has said, I don't want it. Is that clear? Where I start today is with the end of contract, namely damages. If a contract is broken, the remedy is damages. Specific performance, which is an order of the court, the debtor must do something, is only granted very exceptionally if damages are an insufficient remedy. But on the whole, the court cannot order you to fulfill your contract. You are not slaves. The same is, in fact, you have to sue for damages. And that is, of course, the case. You see that through in French law with us. And the Germans should keep in mind that though they have something which tells them they have specific performance, if you look at the Article 888 of the Code of Civil Procedure, you can't get anything more than damages. In England, dating from the time when damages were assessed by juries in civil cases, which had to be instructed by the judge, the assessment of damages is not just in the discretion of the court, but it relies on two separate principles, according as the claim is in contract or in tort. In contract, the damage must have either arisen naturally in the usual course of things, that is to say, objectively, or it must be within the reasonable contemplation of the parties at the time when the contract was made. Natural result is clear. Whatever damages follows from the breach that can be granted. But the other one causes certain difficulties if it is the natural consequences of the contract. Actually, against Baxendale. I gave you, I think, this example already, and I finished damages. Am I repeating it? No, not. In this case, I've given you the example, I think, before. A little piece of machinery, a machine in the west of England broke down, and the owner of the factory sent it by rail to London to be repaired. The They waited too long and didn't send it back in time, and the factory had to stop, and they lost a lot of money, and so he asked for damages for the lost time where he couldn't produce. Answer: that is not a natural consequence if you send a piece of metal by rail to London. You have to tell the other side, but if it doesn't come back within so many days, my factory will stop. In tort, where of course there is no personal relationship between the parties before the damage is done, you can't tell the other side what you will expect of damages because you don't know who you're going to sue. So in that case, it's not the particular damage, but the natural consequences of the act. Finally, one has to keep in mind certain terms of English law which you may not find easy. Liquidated damages. This concerns damages which are fixed in advance in the contract as the so-called genuine pre-estimate of the damages. So you make a contract with somebody and you say, I estimate that if you do not supply the machinery within so many days, my damages will be the following. A genuine pre-estimate of the damage, and you put it into the contract that if it is not performed, that amount of money should be paid. It's called liquidated damages. And then there is something else, exemplary damage. That is damage which is to punish a party because of his or her behavior. So much about contracts. But then there came something else. It's called quasi-contracts. If there's an illegal or invalid transaction and you have performed something, you all know that you have a condictio in debite or a condictio causa data causa consecuta. Need I remind you of that? You all know your work. We haven't got that. But still, we have claims which were developed by the courts in the 18th and 19th and 20th century. The great example today is Lipstein Gorman against Cartney of 1991. Here, a solicitor who was in charge of the finances of his partnership used the money to gamble. In other words, to do games of hazard. And as you may remember, and may I remind you, don't do it. You always lose. And he did. The result was that the institution got the money, he lost it, and his partnerships found out. And what do they say? By English law, gambling contracts are illegal. Therefore, you, the gambling club, have got illegal promise, profit, and therefore you have to return it. And thereby you see the return of the money paid because of an illegal contract. And we have many such cases. I needn't give you all of them. Where people make contracts in order of a gambling kind in order to avoid money, or the famous one in recent times, which I can't quite understand because I'm no longer a good banker, so-called swap contracts, which are illegal between banks. They have paid, the contract is illegal, and the money has to be repaid. All that is known as claim in quasi-contract, because there is no contract, because nevertheless, on the basis of an illegal or invalid contract, money has to be paid and it ought to be returned. It remains a question whether this is a general rule of English law or whether it is limited to a number of cases, which I shall now give you to you, although I'm not sure whether I can say it's a general principle today. This claim, namely on quasi-contract, has been allowed where money has been paid to what we say to the plaintiff's use. If the importer of tobacco, you are importing it, it comes in, it comes to the customs house, the customs demand money to be paid, and before you to do it, your carrier pays the money so that he can get the tobacco out of the customs house. He can come back to you and say, money I paid for your use. Understood? Certainly you can recover on quasi-contract if the money is paid under a mistake of fact. Kelly against Solari, where the pair thought she was under an obligation to pay some tax, and in fact they weren't paying. And finally, in the case of so-called total failure of consideration. Total failure of consideration I dealt with you when I discussed consideration. It means that while we wanted to make a contract and we thought we had made consideration, there was no consideration and I had paid nevertheless, then in the absence of consideration, I get the money back. Wilkinson gives Lloyd. And then another quasi-contract. Money paid, received from a third party to the plaintiff's use. This was the following situation. The government paid a bank a certain amount of money to pay the pensions of their naval admirals. The admiral could claim from the bank the money which the government had paid into the money for their use. Finally, if you have an action in tort, but the defendant has got some property of yours, you can, instead of that, sue in quasi-contract to get the contract, the money back. In more recent times, whenever the contract came to an end because of change of circumstances, Klaus Ray was example, there was no recovery of money which you paid under the contract. That was introduced in 1942 by special legislation. So far, actions for quasi-contract. But then there's another one which has a lovely Latin name, quantum merit, for what he deserved. Somebody made a contract with a publisher to publish a book for children's tales. And the last moment the publisher said he didn't want the contract. He broke the contract. Instead of suing for damages, the writer said, I have spent so much money in preparing that book, and I want that amount of cost to return. Whatever I so far have merit to be given. I now turn to special contracts. Special contracts, which are governed either by binding rules or supplementary rules, those implied, are the following. Sale of goods, and that is the most important one, and is covered by legislation. Secondly, what we call tenancy agreements. That is louage in French law, miete in German law. It's any kind of contract whereby you are allowed to use premises. Partnership, bills of exchange, checks, insurance contracts. Of all these, of course, sale is the most important. And also the most interesting in comparative treaty. It's codified by the statute, begun in 1893. The latest revision is 1994. And it has certain definite features. It deals only with sale of movements, not with sale of land. Sale of land is a very technical material. And I'm not sure whether I should be able to talk to you about land law. And I'll tell you why. I've told you too much, too slowly, and I cannot follow and do everything as I wanted to, including land law. So I warn you, I will not give you sale of land. It's highly technical. The main distinction between English and constitutional law of sale, continental law of sale of land, of goods, not land, of goods, is that English law treats the question of absence of title or quality, the two remedies, which of course you know yourself in the law of sale. It deals with them under the heading of conditions and warranties. It does not introduce what you know in your legal system, that if there's a lack of title or a lack of quality, you have two possible actions, namely to rescind the contract or to ask for reduction of the price. Contim minoris and restitutoria in Latin and Roman law. We haven't got that. What we have instead, so don't believe that you can either ask for the reduction of the price or the return of the money and return of the goods. Instead of that, we have as remedies something called conditions and warranties. Don't think that conditions means what it normally means in contract, which is say, unless I could have jumped over the moon, you won't get me money. That's a condition. A condition here means a right to rescind the contract. And a warranty means a right to ask for damages. And so the purchaser can either rescind or claim damages. But conditions can be waived, so you need not rescind the contract and say, I want damages instead. What are the so-called conditions in the law of sale? Namely, that the seller should have the right to sell the goods. If he doesn't, you can rescind the contract. That if the goods are sold by description, that they actually comply with the description. And if the purchaser tells the seller for what purpose he needs the goods, then if they fail to meet supply him with those conditions, he gets, with these terms, he can get remedy. In the case sale of, in course of business, that the object has satisfactory quality, which you know exactly from your own law sales goods. And I need not go more. Warranties, which is where you could only claim damages, is rather more limited. You get damages because the seller has promised that the object will be free from charges. In other words, that nobody else has a claim to the goods, and or if there are charges, the seller has a right to pledge over it. I sell it to you. You have to tell the buyer. The right to reject goods is lost upon acceptance, and the right to damages remains for the normal period in contract under the Limitation Act of 1980. One thing you've got to keep in mind, reduction of the price, as you find it, for instance, in the German BGB or the Uniform Law of International Sales, has no place in English law. You either rescind the contract or you get damages. Title to in sale, title to the goods, passes with the conclusion of the contract. In other words, there is no need to hand over the object. Title passes with the conclusion of the contract. The risk passes with the transfer of title. The two goes together. So that once title passes, then if the object is destroyed by accident, the risk is no longer on the seller, it's on the buyer. But this may cause tremendous difficulty, and I'm not sure whether I can make clear to you. But I tell you, we've got into a remarkably funny situation. I said that title passes with the conclusion of the contract, risk is the same time. Retention of the title may be very important for the seller, because it assures him that if the buyer doesn't pay, he retains the ownership in the goods. But he may at the same time, as the seller, be anxious to shift the risk of accidental loss to the buyer at the quickest moment possible. So you have two things. He would like to retain his title, and he'd like to shift the risk to the buyer. If, therefore, in general, ownership passes with the conclusion of the contract, and the risk passes to the buyer, the seller cannot claim anything. So that if title has passed early, and it passes, the seller is no longer owner. This is the difficult case. Perhaps I shouldn't worry you too much with it. In certain circumstances, when the seller cannot recover the goods or the damages which he has against the buyer, because the risk is passed, ownership is passed. Nevertheless, sometimes the new buyer, if he makes a claim in respect to the goods, does so, in fact, for the benefit of the original owner, and it's known in German as the Drittschadensliquidation. There is little protection for the buyer who buys goods from another in good faith, which did not belong to the seller. So there you are in a very different situation from the German and Swiss law, where a buyer in good faith can acquire title from a non-owner. Not so in English law. There was once a possibility if you bought in the city of London from a seller in a particular types of goods of something which belonged to a third party, you could become the owner because you acquired it in what is called market ouvert, open market. But that's gone, and you cannot acquire in good faith property belonging to others. So the German 1932, paragraph 1932, equivalent Swiss law doesn't apply. And you can't either rely on the famous French maxim, en fait de meuble la possession du titre. It does not. And I'll now turn to one of the most different matters, but one of the most important of the English law, torts. Although there has been much argument in recent times whether there is a general principle of liability in tort for unlawful damage, or whether there are only individual torts. You may say, nonsense, we haven't got that. Article 138 of the French Civil Code, whenever someone causes damage to another, is liable to make it good. Paragraph 823 of the German Code, Swiss Code, they all say the same. We are not sure whether I have a general rule of liability in tort. And you will see now why. In short, the tradition which in Europe is based on the Lex Aquilia, Digest 9.2, a general rule, is probably not that of English law. On the other hand, the law of tort is more important in English law than anywhere else. And you'll see why. The contract is limited in use because of the technicalities of the concept of consideration, which, for instance, ignores contracts in favor of third parties, the absence of any provision allowing you to pursue in tort rather than contract. Up to the end of the last century, protection was accorded not on general rules of tort, but for specific types of tort. And we live by that still today. First of all, intentional interference with the person. This is, if negligent, and negligently run you down in a motor car, is known as trespass, so it's actually the negligence. If it's done intentionally, it is called trespass. And there are plenty of cases for that even today. Merely to intend to do damage to somebody else may not be enough for claiming damages. That is still a great problem based on the case of Wilkinson against Downton in 1897, where somebody, in order to annoy another, told her that her husband had suffered a terrible accident, when in fact it happened. Somebody called the telephone, get it done. Go on. All right. Must be warning sign. Oh. All right. So, intentional or negligent damage is trespass or negligence. Non-physical damages are the best is deceit. When I tell you a false story in order to get you to pay me some money, I have deceived you. You have an action in tort. So you have injury to the person, willful or negligent, intentional deceit, or now one which you have never heard of before, intentional interference with contract. I'm afraid you're getting nothing but new things. At the end of this hour, you'll be absolutely exhausted. I shall be too. Lumley against Guy. This was a 19th century case in which a German singer, lady, made a contract with one opera house in England to sing there. And the director of another opera house in England persuaded her to break her contract with Opera House 1 and come to him at Opera House 2. He was liable for inducing a breach of contract. The fact that he had persuaded somebody to break her contract can make you liable in damages. Then there's intimidation. This is famous. Supposing you have a ship and you use as a crew people from countries which have no trade union and whom you pay much more cheaply. It is quite usual to do that with people coming from the Philippines. If you, with that ship, you go into a country where there are strong trade unions, they may object to it. And they may stop your ship, not allowing the ship to leave, with the result that you either lose a lot of money or you have to promise your crew to pay them better. That is intimidation, and you may be liable for doing it. Similarly, if two parties agree to a certain course of action, which causes a third party illegal damage, conspiracy, you are liable to. So we have already quite a lot. Conspiracy means that you agree to do a certain thing either by unlawful means, you threaten to stop their machinery, or with an unlawful purpose, namely in order to make gains. But on the whole, trying to ruin your competitor by undercutting and pay your costs until he goes bankrupt is your good right of competition and is not illegal. And finally, one thing which probably again will strike you as extraordinary: defamation. Defamation, which for you in your country is probably mainly criminal. In England, it is a civil action. And what's more, people love it. If I hear on the wire that it says that a well-known law professor in Cambridge has been stopped at customs duties carrying a lot of heroin, and I can prove that everybody thinks it's me, and that my reputation has been ruined, although it wasn't, I can get damages. It's known as a gold digging action. You make money. And there are two types of defamation: libel and slander. Libel is a Latin libello, meaning written, and you needn't prove damages if the damages are obvious. Or slander, which is spoken insults, where you have to prove damages. So here are a number of the torts which you could sue on, which were developed over the centuries, and these are the ones concerning the person. But there was also interference with property. Direct interference with property, you take my bicycle, apart from criminal, is trespass to goods. Or if you keep my bicycle, which I lent you, then and you fail to restore it to me, you will be liable for conversion, for keeping the property. It's now the 1977 Act. And then there is torts to land, trespass to land. If you will come into my garden, you are liable for an action for trespass, and I need to any particular damage for it. It automatically leads to damage. They may be very small, and it may cost me more to sue you than I get, but trespass to land gives me a right of action. So if I give a party and I put down one table full of champagne bottles, and you come in and interfere, not taking champagne, but using a garden hose and spraying water all over the place so that nobody could come and drink the champagne, that would be trespass to them. Oh, and then come the famous cases. Malicious nuisance. Nuisance is any interference with one's enjoyment of property. Bradford against Pickles. The city of Bradford was establishing a water supply. Mr. Pickles was nearby and he had a wonderful fountain of water. And he was very much afraid that he would lose it. So he dug and made it big, with the result that the water couldn't reach the city of Bradford, but would be on his land. And Bradford sued him for damages because he intentionally wished to cause damages to the city. Or Christie against Daly. Somebody had a neighbor who was a music teacher. She didn't like hearing that noise. So the person who was the neighbor rattled on the walls for hours on end in order to stop the music teacher teaching music. That is an action for nuisance. Or the famous one on the Silver Fox Farm against Emmett, where there was a Silver Fox farm and the neighbor didn't like it. I don't know whether it smell or anything else. So what he did was he started shooting with guns, making a terrible noise, which meant that the person who had silver foxes next door hoped to breed some, so he had new ones and could use their fur. They suddenly couldn't breed any longer, and so he lost his business, merely because the other one shot in on his land, which you're perfectly entitled to do, provided you don't intend to damage somebody else. And then there are so-called public nuisance. Interference with members of the public in general. You don't like my business, and so you organize a big meeting outside my shop because you think I am acting on it. That might mean public nuisance because nobody can walk on the pavement or in the street while you are having this enormous meeting outside. That is public good. And then there is the famous rule in Rylands If you bring onto your land objects which do not normally belong to you, and they escape from it, you are liable. So if you start on your land a pond of water because you like some ducks to swim in, and the pond breaks and the water runs down the hill onto your property and damages everything, you're liable not because anyone did anything, not because of intentional negligence, but because the other person had brought something onto our land and it had caused damage. In other words, the accumulation of non-natural service. And then we have a lot of legislation about dogs, dangerous dogs, and then libel and stuff like that. Have I mentioned that before? I think I have. Look. I have. There's only one. It is the action for defamation. And again, it is one which is quite popular because it brings in a lot of money from capital, and you practically always find in the law reports somebody who's suing for libel or slander. In other words, I'm accused of having beaten up my wife, and in fact I've never done it, but the newspaper says that I have. I can bring an action for libel. Libel means written defamation. Slander means spoken defamation. And if it's written defamation, I need to prove damages because it's there. It's forever. Everybody can see it. If it's slander, spoken, I must prove my damages. So if you accuse me of beating my wife, and you do it only by telling my friends, I have to prove damages, and I find that a little difficult. And then there is something we don't know whether we have an action or not. The action for privacy. If you try and bring a camera into my garden because I like a private garden where I can sunbathe in the nude, and you bring in this camera, then I might be able to sue you for damages for the interference with my private life privacy. But it's by no means clear whether we have that action yet. We certainly had a beginning in the case brought nearly 200 years ago, in the case of the husband of the Queen, Prince Albert, whose paintings were copied by outsiders. And it certainly he was allowed an action because of interference with his private life. It's much more famous in American law, where there are famous articles on privacy, especially by Brandeis for Harvard Law Review. More recently, new talks appeared, so-called Euro talks. They are based on the violation in a particular country of rules made by the European Commission, say on how to make contracts with restraint of trade, and the like. All this happened in the 19th century and up to now. And it still is at your disposal if you want to sue. But now comes the new word. Donahue and Stevenson. Have they lectured to you about that one? The snail in the bottle. You heard about it? You had that already? Mr. Weir or who? So need I tell you a story again? Well, I did. A lady went into a restaurant and wanted to ask her for beer. She got it. And when she opened it and doesn't drink it, she found a dead snail in it. And that gave her such a shock that she became ill and she wanted to sue. And she wanted to sue the restaurant. Is he now? You see, here we come to the equivalent of what the continent had since the days of Roman law. The lex equilia, whoever those done is to another, fully or negative, they should be allowed with good. 1382 in French Rome. What did the court say here? You must avoid acts or failure to act which you can reasonably foresee is likely to injure your neighbor. You have to think with your action whether or not there is a likelihood that your neighbor, what is your neighbor? That is the question. It's a person who is within your reasonable contemplation. And therefore we suddenly found in 1932 a new type of action which said that if we interfered and caused damage to another way, you could reasonably think that a neighbor would be harmed, you are harmed. And now comes the wonderful answer. Where does this principle come from? It comes from the House of Lords. But the House of Lords is our highest court, and it's court of appeal not only from England, but also from Scotland. And this is an appeal from Scotland. And Scotland has Roman law, and this is in effect bringing home into England the old good lex equilia, but now in the form of an English rule. And we have lived ever since with the question, is it foreseeable that you could make damage? Will it affect a person who you have to consider your neighbor? Who is your neighbor? Because it doesn't mean just somebody sitting next to you. And the amount of problems is therefore enormous. The Germans will realize that it's easy, who is my neighbor, Verkehrserpflicht. But Donnelly and Stevenson was the beginning in 1933. What does it mean? Actions for shock. A lady hears from a messenger that her husband and his children have a road accident and one badly injured, another being killed. She has a terrible shock and she tries to sue the person who caused the accident. Donnelly and Stevenson, you have to consider if you run down somebody, that somebody else will get a terrible shock in the family. Doctors who find that they have a patient who has rubella, which I don't have to tell you, but it's an illness which can affect badly any babies whom you carry. He has to tell the future mother that there is a danger here that the child will come that will be born with defects and must draw attention to the need perhaps for abortion. If he fails to do so, the child is born and is incapable, the doctor is liable. Sterilization. The doctors who sterilize a husband who says he's had enough children, he doesn't want more, and after that he has another one. The doctor may be liable if he either did it badly or failed to point out that he has to wait a certain period. On the other hand, if you injure me with the result that my whole personality changes, and I now become murderous and run around the country murdering people, you can't sue the person who ran me down for having caused the murder of third parties. So much about a person. But also property damage falls under the next If a cable is cut of an electric cable, you can only sue for the economic loss. In other words, the cutting of the cable. And if the city is under an obligation to control buildings for health reasons, and they fail to do so, you cannot sue for damages except if the failure to carry out the instructions of the city for building led to actual health defects. But other things can also lead to damages. Headley burn, I guess I should put it other way. Misleading statements. If I make a statement because the bank asked to give a statement whether I am sufficiently responsible financially if you want to sell me a car, and they say I am, and it turns out that I am in fact a banker, the bank will be responsible for making a statement, a wrongful statement. Even something before the act occurs can be cause liability. It's very much like what is known in some countries as culpa in contrahendo. If I'm told by an oil company when I want to put up petrol station that I will be able to sell 10,000 liters of oil a month, and I find out that I cannot, and that the oil company told me this was a mistake, negligently, they are liable for having made a fault in contracting agreement. It's something which the Germans know as culpa in contrahendo. I don't know whether it exists in other countries. And then a street. If I tell my solicitor that they must make a will whereby they benefit my much beloved girlfriend, and the solicitor is slow and doesn't do it, and I die. And my girlfriend now doesn't get any money. She turned round and sued the solicitor because she said she had a duty towards her under Donald Stevenson as the nearest neighbor, because she could see she was going to be beneficiary. And if she didn't do things correctly, she would lose everything. That has led to quite a number of cases where people who are solicitors in Ireland who failed to carry out instructions were held to be liable to the beneficiary if they hadn't done it. Similarly, of course, if somebody tries to take over the business and tries to find out whether the business is solvent, and he goes to the accountants to find out, and they give a favorable answer, and the answer was mistaken, the accountant is now. We had an enormous amount of litigation in cases where buildings were put up which should have been built in accordance with certain instructions by the local authority, building instructions, and they weren't. And when the building therefore had to be built, the owner tried to sue the local authority for having failed to control the building. Answer: if you haven't got any damages, there is no action. So, failure, the duty towards your neighbor does not give you action unless you suffer some kind of damages. The chief of police of an area is not under a general duty to protect you against interference by criminals. So that if you are murdered or injured or anything else, you cannot turn around and sue the chief of police for having failed to protect you. There is no general duty to protect on the public authority to protect you. On the other hand, you always have to work out, is there a special relationship which creates you to be the neighbor of the other one? If somebody has a building which he closes down, and because he wants to pull it down and create better building, and while this is happening, people are trying to get into the building and trying to make mischief, and they put out a fire, and the fire spreads, and it spreads to the neighbor. Can the neighbor sue you for having failed to stop the interfering torchbearer? The answer is, it depends to what extent there was a relationship of responsibility to you and the neighbor. If, on the other hand, you are sold a house, and it turns out that the title is wrong and you can't move in, and so you have to go and hire a house in which to live, and if you happen to be too poor to claim the money, can you sue the party who sold that house to you originally? Sue for damages because you couldn't sell the house, had to go somewhere else? Answer: no. Damages. I feel I'm overshooting my time. No specific damages need be proved if the tort is what we say called actionable per se. There are certain types of torts where damage follows automatically. If you move into my garden without my permission, I can claim damages from you without proving damages. I get half, 50p. I wouldn't get much, but I get damages. There was a time when, if I had a ship and the ship was damaged by another, and I have an action against the tortfeasor in the collision, and thereby I lose a good contract because I had promised that my ship would be used for the next 2 years in trade with China. And now I can't because the ship is being repaired. Question: can I sue? fact that you must repair the ship, and that it costs them, and may cause you damages. But you cannot say, I can claim damages because I'm too poor to pay for the repairs of the ship. In other words, if you suffer damage, and you're too poor to have the matter repaired, it used not to be a claim for damages merely because you're too poor. That has been overruled a few weeks ago. If several people are liable negatively damaging my motor car, the liability is divided between them. We have no partie civile proceedings as the French have, where in a criminal proceedings you can add your civil claim. But the Criminal Justice Act 1972 does allow you a certain